there are certain crimes for which there is no bail provision. As in, if you commit a crime, there would not be any bail and the case will go on. Such crimes are called as non-bailable crimes. Such crimes are non-bailable crimes. Now, there is a sidestepping present in this. When there is a non-bailable crime, but there is a catch here. Non-bailable crimes, you will not get the bail. But if you anticipate, if you think that you may be arrested in the coming days, in the coming future for a non-bailable crime, you can apply for anticipatory bail. You can apply for anticipatory bail. So what is anticipatory bail? If you are thinking, you have an understanding that you might be arrested in the coming days for a non-bailable offense, then you can apply for the anticipatory bail. And if you do that, if your anticipatory bail is granted, then if the police is arresting you for a non-bailable offense, the judge would ask the police to release you. They may not arrest because you can show the anticipatory bail, but if you have been arrested, later on you can show the anticipatory bail which was already beforehand taken, and the judge would then ask the police to release you. So this is the concept of non-bailable offense and anticipatory bail. Now, I said that this is non-bailable. There are certain offenses which is non-bailable, but still there is anticipatory bail which you can apply for. Now, coming on to the SC/ST's Prevention of Atrocities Act. Now, under this act, the offenses are non-bailable. Since they are non-bailable, you will not get a bail, but you could apply for anticipatory bail. However, specific, because it's a non-bailable offense, you can apply for anticipatory bail. But specifically for SC/ST Prevention of Atrocities Act, it prohibits under CRPC for you to get an anticipatory bail. Meaning, if you have committed a crime under SC/ST's Prevention of Atrocities Act, you will be arrested and that offense will be non-bailable, and you cannot even apply for anticipatory bail because this provision is not there specifically for offenses under this act. Clear? I hope this concept is absolutely clear. Now, why this particular thing is in news, anticipatory bail under SC/ST Act? Because the law which I said just now is one thing, but recently a Supreme Court judgment has come which sort of details that it need not necessarily be this which I have just mentioned. So let's go into the detail of this particular judgment. Okay, so recently a two-judge bench, important to know it's two-judge bench, it's not a constitutional bench, that's point number one. Point number two, to overrule this two-judge bench, how many judge would be required? How many judge bench would be required? This is a very interesting question which can be asked for prelims. If I ask you, the previous decision was taken, let's say, by a 5-judge bench, and if I ask you that this judgment needs to be overturned, so how many judges bench would be required? UPSC can ask you that in prelims. The options would be any number of judges, 6 judges minimum 6 they may write, minimum 9 they may write, or 5-judge bench. Now what's the answer? People may take this, but even a 5-judge bench will do. Why? Because it would be the more recent of the judgment. So this judgment has already taken place. Now 1 year later or 2 years later or 10 years later or 1 day later, again a 5-judge bench is constituted and they give a judgment which is opposite or different than this, then this judgment would supersede the previous judgment. So even a 5-judge bench is good enough, right? But generally you do have a higher number of judge benches when you are dealing with it, right? But even if the same number of judges bench is there, it will still supersede because it is the most recent judgment. Remember that. Anyway, coming back onto the topic. So recently 2-judge bench of the Supreme Court had held that bar as in prohibition. The prohibition on anticipatory bail under section 8 of the SC/ST's Prevention of Atrocities Act is not applicable. I told you, under SC/ST Prevention of Atrocities Act, you do not get anticipatory bail. That anticipatory bail is prohibited. But that prohibition will not be applicable is what the Supreme Court is saying. Unless, this word is important, unless a prima facie case under the Act is made out against the accused. Now what does this mean? Unless a prima facie case under the Act is made out against the accused. Prima facie means by the look of it. Prima facie means that it looks like that there is some case against this accused. This accused is actually looking guilty prima facie by the looks of it. Right? So unless and until by the looks of it, by judging, if the person is not looking to be guilty, then this prohibition will not hold good. If prima facie, by the looks of it, the person is looking guilty, then this can hold good. So what is this prima facie judgment looking, the accused looking guilty? What does this mean? Let us understand that. This means that the person who has committed the crime, had the intention to humiliate based on caste identity. Had the intention to do that. It is not that, in the heat of the movement, two people were fighting, two people were arguing, and one of them had passed certain remarks or said something, but never intended to do that. So there was no intention, and there was no awareness probably also. There can be lack of awareness also. If someone is saying something, they may not know that from which caste the other person belongs, and may end up saying certain things which they are not aware of, can be derogatory to them. So there is no knowledge, no awareness, and no intention as well, right, to harm the person. But if there is knowledge, if there is awareness, and you actually intend to harm that person based on their caste, then there is a clear intent, and then there will be prohibition on your anticipatory bail. You will not get it. I hope this is absolutely clear. So the accused need to have intention to humiliate based on caste identity. Based on caste identity. That means what? See, you can pass out remarks even between friends. This happens. You say things, etc., etc. But if that is based on caste, that is an issue. You may fight based on. You may call someone fat, someone thin, someone tall, someone short, etc., etc. All those things are there. But based on a caste, that is a crime, of course. Okay. So only intentional insult and intimidation caused by entrenched social norms. So it should be intentional. Social norms like untouchability, caste superiority, all these things would qualify as a crime. Okay. Now, what is anticipatory bail? I hope this was made absolutely clear. Anticipatory bail is basically you are anticipating that you may be arrested for a crime, so you are applying for an anticipatory bail so that the court gives a direction to the police to release you if they have arrested you in case of a non-bailable offense. I hope that's absolutely clear. Now, coming on to the SC/ST Prevention of Atrocities Act. What is the objective? Of course, the objective is to prevent happening of offences against the members of SCs, right? For this, special trial courts are available for such offences, and provision for relief and rehabilitation of the victim is there. So atrocities have been happening since time immemorial historically. That is why this protection or this act was needed, and under this act there would be special courts for such trials, right? This is a non-bailable offence, and there would be provision for relief and rehabilitation of victims. Because under this act, a lot of crimes like untouchability is there, social exclusion is there, people being excluded from the society, from the temple, from various places, from the wells, from drinking, prohibited from drinking water from the wells, etc., etc. The basic necessities have been excluded from them, and all this would come under this act, and it is a crime to do so. Now, there are certain features of this act. Now, certain feature as I say, if it is, discriminatory remark, derogatory remark based on caste is there against an SC/ST person, then it is a crime. But the accused should not be from the SC/ST community. That is a requirement. If both of them belong to SC/ST community, then there would not have been any offense to have taken place. So the requirement is the accused must not be a member of SC/ST community. Okay? The offenses, of course, can be various offenses. Let's say one more thing, employing members of SC/ST for manual scavenging. Even this is an offense. Employing SC/ST person for manual scavenging is an offense. Dedicating SC/ST women to deity, right? Devdasi system, denial of customary right of passage through places of public places, temples, etc. So all these things are crimes under this act, and it provides for punishment for neglect of duties also. If a government official is not doing their duty, so it provides for punishment for neglect of duties under the act. By whom? By the public servants as well. However, they also should not be a member of SC/ST. So basically, remember, any accused under this act cannot be a member of SC/ST. If they are, there would not be a case against them, right? So I hope that is absolutely clear. You should know, as per the SC/ST Act, there was a prohibition on the anticipatory bail, but the Supreme Court has said prohibition is fine. But if there was no intent and prima facie there is no such case of intent and all, then this prohibition will not hold good. If there is an intent to derogate, to intimidate, etc., then yes, then that application of law would apply. Thank you.